Hello, my name's Declan O'Dempsey. I'm a barrister at Cloisters Chambers, and this is a talk about how employers can help to deal with the upsurge of racism after the referendum on whether to leave the European Union. Employers are very well placed to uphold the British value of tolerance. I'll explain why I say it's a British value in the next slide. In this presentation I'm going to cover the whys and wherefores of putting resources into anti-racism messages. Then I'm going to look at what you can do if a racial incident takes place both in the workplace, but also what happens if a worker engages in racist behaviour away from the workplace. There are of course criminal offences that may occur, but I'm going to focus more on non-criminal incidents and how you can make it absolutely clear that that behaviour is unacceptable, both in work and out of work. I'm also going to mention how the courts and tribunals have dealt with racist conduct in these sorts of situations. So why take action? The government's Prevent strategy talks in terms of British values. Well, British values will include the value of tolerance and very clearly includes the value of belief in the rule of law. There is already certain legislation in place that employers will be aware of. Anything done by an employee in the course of their employment is treated as having been done by the employer for the purposes of the Equality Act, and in particular if it constitutes an unlawful act under the Equality Act 2010. And it's important to remember that that's regardless of whether the employees' acts were done with the employer's knowledge or with their approval. But here there's a defence available to an employer who can show that it took all reasonable steps to prevent the employee from doing the discriminatory act in question or from doing anything of that description. So for example, insulting a service user racially, what has the employer done to prevent employees behaving in that sort of way? Well, the case law shows that the employer must have taken such reasonable steps before the act of discrimination or harassment occurred. It's not enough reasonably to react to a complaint of discrimination or harassment. In other words, you've got to be proactive. Simply having a policy is insufficient. You've got to take steps to implement it. So, is it worth conducting anti-racism campaigns? Remember that you've got the overall problem that you won't have the employer's defence if you didn't take all reasonable steps to stop the type of act which actually has occurred from occurring. Now, for large organisations, it will be worth having poster campaigns, information campaigns, and positive message campaigns through the workforce at this time to show that racism is not acceptable. But for a lot of employers, they won't have the resources to do this. So how are you going to comply with at least the defence requirement, as well as making an effective contribution to eradicating racism within society? Well, it's very important to put out a positive message about diversity in the workforce and also in society to do that. At a minimum, you need to ensure that the physical environment is free of racist graffiti, that the work environment is free of racist conduct, and that such conduct is eradicated from the electronic sphere as well as the physical sphere at work. You should ask yourself whether your definition of gross misconduct includes the fact that engaging in unlawful discrimination or harassment will constitute gross misconduct, but it's also sensible to have the bringing of the organisation into serious disrepute as another example of gross misconduct, because it may be that the racist behaviour that you are wanting to eradicate has not in fact been rendered unlawful by the legislation, but it still may bring the organisation into serious disrepute. So what's necessary for this reasonable steps defence? Having and implementing an equal opportunities policy and an anti-harassment and bullying policy, and reviewing those policies as appropriate. Now may be a good time to consider whether your policies are sufficiently strong. But for reasons I'll give later on, most of the time the answer will be yes, they are sufficiently strong. It's simply a question of making sure that you implement them so as to send out a clear message that this kind of racism is unacceptable. So that means making people aware of the policies themselves, but also their implications. So you may want to make it clear that casual racism on an employee's own time may be the kind of behaviour that brings the company into disrepute and that it is unacceptable. It is necessary, in order to show that you've taken all reasonable steps, to ensure that you've conducted training for your managers and supervisors, or staff generally, on discrimination and harassment and avoiding discrimination and harassment, both in relation to other employees, but also, for example, in relation to customers and members of the public. You should deal effectively with complaints, and it's worth keeping a record of when complaints come in and how you dealt with them. But dealing effectively with complaints will include taking appropriate disciplinary action. Now, on this slide is a policy that may be worth having. Here the employer is saying that harassment of or discrimination against employees, contractors, clients or members of the public relating to, and then there's a list of characteristics: gender, marital or civil partner status, gender reassignment, race, colour, nationality, ethnic or national origin, disability, religion or belief, or age, which is contrary to the equal opportunities policy or the anti-harassment and bullying policy, if you have those, is going to be regarded as misconduct, at least, and you may want to point out that it may be considered gross misconduct. It's important to recall, though, if you're a small business, that you don't always have to have this type of explicit definition to capture some of the very offensive behaviour that recent days have shown. There, it would be enough to say, look, this is obvious. Anybody looking at this would have regarded the kind of behaviour that you've engaged in as gross misconduct, and it doesn't need to be set down in a rule. So let's turn to how you deal with racism within the workplace. Very straightforward. You treat it as a matter of misconduct. You ascertain the facts as quickly as possible. You consider suspending the person accused as a neutral act pending the completion of the investigation. You take statements from people alleging the racist behaviour and from the accused. You make sure that you follow the ACAS code and guidance on discipline and grievance procedures. And you conduct a disciplinary hearing. So looking at incidents of racial abuse, you'll be looking at what probably happened and what witnesses were around, and whether any of the people involved had motivation for lying. It's important to look at that idea of what probably happened. Very often people investigating allegations of racial abuse tend to worry about how certain they need to be that the incident happened in the way described. Actually, all tribunals will be interested in is the conclusion you reached about what probably happened. Similarly, looking at the motivation of people for lying, this goes for everybody involved. The person bringing the allegation, if there isn't some reason to believe that they may be lying, then why would you treat that any differently to any other allegation made by a person? So you'd be looking to see if there's some good reason to suppose that they were lying. And it may be that the person who's being accused will be able to set you on the train of ascertaining facts which might indicate that the person was lying. But if they can't do that, then one has to ask why the person is making the allegation, and if no good reason is shown to suggest that they're lying, then you'll have to reach a conclusion on the basis of what you think is probable. In some cases of racial abuse at work, there'll be a risk of intimidation of witnesses, and you don't always have to identify the witnesses to the person being accused. The substance of what they're saying needs to be put to the witness, and you should bear in mind that it makes it more difficult to investigate their motivation if the person accused is not able to identify them and say, well, for example, Charlie has this grudge against me going back several years and he's just lying about this. By the same token, you may be able to reach a conclusion on the balance of probabilities as to what happened, even though you can't probe the motivation of those witnesses. If you're thinking that you may need to rely on anonymous witnesses, it's probably a good idea to seek a little bit of legal advice on that. So suppose that you have established that an incident of racial abuse or an attack, for example, has taken place, i.e. it's more likely than not that it took place. Now you'll have done this after hearing the evidence, both at a disciplinary hearing and after your investigator has conducted a reasonable investigation. You've still got to ask yourself whether there are any mitigating circumstances. Post-referendum volatility, or some claim that they were entitled to say what they said because of free speech, these are unlikely to be mitigating circumstances. I'll talk a little bit more about free speech later on. So then you've got to ask yourself, is the conduct so serious in the light of all that as to amount to gross misconduct, or does the mitigating material mean that dismissal shouldn't be the answer to this? Or could I remedy this misconduct by means of administering a warning or a final written warning or some lesser sanction? Now, most policies would list racial abuse as gross misconduct, but whether or not you've got it listed in your policy or your disciplinary policy as such doesn't really matter, because it is behaviour which is so serious as to be likely to be accepted by a tribunal as constituting gross misconduct, entitling you to dismiss summarily. Obviously, everything is going to turn on the individual facts you've got before you. But for the most part, this kind of behaviour will be viewed as very serious misconduct. So it doesn't have to be listed as an example of gross misconduct in your disciplinary policy. If the behaviour is the kind of behaviour which, if you just heard about it, you would think, my goodness, that is just completely wrong, and that's obviously misconduct, then that's going to be probably sufficient to bring it within the definition of gross misconduct. You don't need, for example, anyone to tell you that an employee stealing from you constitutes gross misconduct. So it doesn't matter if you have that in your disciplinary policy as an example of gross misconduct. As it happens, most people do. So after all that, you need to consider what the proper sanction is. And as I've said, you'll have a range of things to consider, from dismissal, final written warning, warnings, etc. So the tribunal would expect an employer to be able to show that there is a potentially fair reason for dismissal of an employee who's got more than 2 years continuous service. In an unfair dismissal claim, which might be brought against you, it's for you to show that the racial misconduct was the reason for the dismissal. So you must have identified the conduct on which you relied. And the ACAS code says that you should investigate the issues as we've discussed, inform the employee of the issues in writing, so it's important to identify the conduct you're relying on at that point. You should conduct a disciplinary hearing or meeting with the employee, and don't forget that they will have a right to be represented. And you should inform the employee of the decision in writing. You should also give the employee a right of appeal. So when the tribunal is considering the substance of the complaint, they'll ask themselves, well, did the employer believe the employee probably misconducted themselves? Did the employer have reasonable grounds for believing that they did? Did the employer conduct a reasonable investigation? And was the belief that racial abuse or misconduct had taken place a sufficient reason for dismissal as opposed to another sanction? It's important to bear in mind that it's not a one-size-fits-all solution. The tribunal will look at your size and administrative resources, but it'll also consider the justice of the case, the equity and the substantial merits of the case. But they will ultimately ask the question whether your decision was within a range of reasonable responses to the conduct which a reasonable employer could take. I want to turn next to the situations where an employee abuses your email system. It's wise to say in your policy on email use that no one has permission to use the email system for discriminatory material, and in particular racially offensive material. In one case, the Gosden case, and this is just a tribunal report, there was a fair dismissal in the case of somebody who sent a racially offensive email outside working hours from their own home computer to another employee's home computer. However, the offensive email did put the employer's reputation at risk because the employee had no control over where it was going to go and had put in it the phrase "pass it on." So clearly there was no control at all, and it was perfectly reasonable for the employer to conclude that the employer's reputation was being put at risk by this. So conduct which occurs not even at work can result in a fair dismissal. So I want to talk now about tweets. It's quite important in this context to work out how public the tweets are. So you will want to ask whether the employee restricted their settings to private. You want to find out who's following the tweeter, other employees, customers knowing that the tweeter is an employee. Can the remarks be seen by fellow staff, employees, or by the general public? So if it's not restricted to social acquaintances, it doesn't matter whether or not people have to make a conscious decision to follow the tweeter. And these principles have been summarised in an employment appeal tribunal case in the UK called Game Retail Limited and Laws. It's not necessary to show that someone was actually offended in this context. So if you come across a tweet involving racist language, you're entitled to reach the conclusion that the tweets might cause offence. You also don't have to show that they're derogatory towards the employer. The real question is going to be whether they bring the employer's organisation into disrepute. And quite plainly, racist abuse or racist language does bring the employer's reputation into disrepute in the minds of right-thinking members of the public. There is, however, a balance to be struck between your desire to remove or reduce reputational risk from social media and the right of free expression. And that's true, which is why simply private communications may well not be capable of being challenged, and language which is offensive but not, for example, race-hate language, may well not constitute unlawful discrimination, but it still may represent a substantial reputational risk to your business. It's worth remembering that the right of free expression, which is guaranteed by the European Convention on Human Rights, incidentally, is to be exercised responsibly. It doesn't allow hate speech to be used. So the extent of the right of free expression might depend on the type of work that's being done. And if, for example, a person has been racially offensive towards the racial group constituting the majority of the client group in their work, that may be highly significant as well. So I'd like to conclude now with a few remarks. It is important to send the message that racism has no place in society, regardless of the outcome of the referendum vote, as the vast majority of the population abhor this kind of racism which we have seen occurring in the past few days. But it's also important to protect your business from allegations of racism by your employees towards members of the public and customers. Employers are also very well placed to send the stabilising message to society, namely that regardless of our direction of travel, we are not aiming towards a society which is intolerant of diversity.